Hello and welcome to today's web seminar. Today we'll be discussing how CSA and SMS scores impact your trucking business. This web seminar is brought to you by Cline University and features a panel of guest speakers, including Rob Abbott, VP of Safety and Compliance at the American Trucking Association, Steve Bryan, CEO of Vigilo, and Ted Perryman, an attorney at Roberts Perryman who specializes in transportation litigation. Before we begin, a little bit about the technology we'll be using today. All of your lines have been muted for the duration of the web seminar, but you can enter any inquiries that you have via the question box or chat box, and we'll queue them up for the conclusion of the presentation or respond to your questions via email. You can also slide the GoToWebinar box closed by clicking the orange arrow or double arrow, but do not click the black X or you will exit the web seminar. Now, without further ado, I'd like to welcome our first guest speaker, Rob Abbott. Rob, the floor is yours.
Well, thank you very much. And for our attendees today, it's worth noting that Steve, Ted, and I have given a similar presentation or set of presentations recently, both at the American Trucking Association's Management Conference and Exhibition, but also at the ATA General Counsel's Forum this past summer. Our intent here is to talk a little bit about some of the things that impact carrier scores, both with respect to the reliability and significance of those scores and some of the data concerns we have. Regional enforcement disparities, but then also how those scores might impact carriers in litigation. So I'll start first today by talking a little bit about CSA generally. As many of you know, CSA is really a program that has two purposes if you read the FMCSA's methodology. The first is to prioritize the least safe carriers for enforcement. FMCSA has limited enforcement resources. They really can only audit approximately 3 to 5% of the carrier population annually. So they have to carefully prioritize their enforcement personnel and resources. The second is that if you read the methodology, it says the purpose is to provide third parties with important information with which they can make safety-based business decisions. So these are the two purposes, and in some ways we're going to look at some issues with the system and how they fit those two different roles. It's important to back up for a moment and know that, of course, while we are at times critical of CSA, it is a program that has many positives, of course. It's performance-based. It focuses on primarily performance measures such as roadside inspections, whereas predecessor systems relied heavily on record keeping. And I think we would all have to agree it's placed a greater focus on safety, greater emphasis on safety. That which gets measured gets improved, of course, and fleets have devoted greater resources and attention, as have drivers, to safety issues. And finally, of course, FMCSA at times has been receptive to calls for improvements to the program and has made improvements, certainly not all that we've asked for, but they have made a number of improvements at the calling of the industry and others. So these are all positives with the program that I think are important to acknowledge. The question in the context of both purposes, both prioritizing fleets for intervention and providing third parties with safety information, is whether or not these scores are reliable. And in that context, we know that a lot of people have pointed to some weaknesses in CSA, and they really fall into two large categories. One is data quality issues, and the other is methodology concerns. With respect to data quality, the issues are data sufficiency. How much data does the system have, and is it enough to draw comparative measures about fleets compared to other fleets in the country? And then also regional enforcement disparity, the fact that we create comparative scores by comparing fleets that operate sometimes in two different areas of the country where they are subject to different enforcement thresholds and focuses. So also with respect to methodology, there's a number of ways that scores are developed or assigned. And one thing that impacts that is, for instance, the fact that the system counts all crashes, including those that a fleet could not have prevented or did not cause. And the severity weights, or the points that are assigned to violations, in some cases appear to be illogical or impact the reliability of scores. So let's look a little bit more deeply at some of this. With respect to data sufficiency, the issue is there enough data on these fleets to draw really meaningful comparisons? So FMCSA says that they have sufficient data to evaluate, quote unquote, 40% of active carriers. So 60% are not evaluated in any way. And it's important to understand that to be evaluated doesn't mean you have a score. It means that in at least one category, you've met the minimum data sufficiency threshold. That is, In some categories, you've had at least 5 inspections, or in other categories, you've had at least 3. And that could be 3 walk-around inspections or 3 driver-only inspections, such as when an officer says, show me your license, med card, and logbook. But FMCSA says that that really shouldn't be a concern because they have data on the fleets that are involved in 92% of crashes. And the importance here is that that's 92% of crashes that get reported to FMCSA. ATA estimates that as many as 35 to 40% of crashes don't get reported. But also that statement alone can be a touch misleading in that it says that they have data on the fleets involved in 92% of crashes. But you can get there by having data on the nation's largest fleets. But that doesn't necessarily mean you have data on 92% of carriers involved in crashes, just the carriers involved in a large portion of crashes by getting at large carriers. So roughly 18% of carriers have at least one score. Far fewer of scores are scored in most categories or in all. And of particular interest is that small carriers are underrepresented. If we look at a GAO review of the CSA op model test that was conducted in 2008, 2009, and 2010, they said that CSA only had adequate data on less than 10% of small carriers. And that's important because more than 80% of trucking companies have fewer than 5 trucks. So again, the question here is the data set representative of fleets nationwide? So if we say that a carrier has a score and is relatively unsafe, who are we comparing them against? And we're comparing them against the other fleets on whom the agency has data, not necessarily all fleets. We're also concerned about what the scores mean. Are they reflective of whether or not fleets are safe or unsafe, more likely to have crashes, or whether or not they have violations, compliance issues? But those might not necessarily correlate to crash risk. So if we look at 3 categories, unsafe driving, fatigue driving or hours of service, and vehicle maintenance, as these charts from the ATRI study recently showed, was that in these categories that on average, as fleet scores rise in CSA, so do their crash risk. And in some cases, the relationships are rather modest, and in others, they're less so. But in 2 categories, controlled substance, alcohol, and driver fitness, there's an inverse relationship if you look at this data based on roadside inspections. That is, the higher the score, the lower the crash rate. And finally, if you look at the hazmat basic, there really is no relationship between scores and crash rates. It's merely a measure of carriers' compliance with the regulations. That is, it reflects that they have a pattern of hours of service violations, probably related to things like paperwork, shipping papers, and placarding. So really, when we look more closely, it sort of begs the question, should these scores relate to crash risk, and what do they mean? What's their significance, and how reliable are they? And one can argue that the agency has an obligation to ensure compliance and enforce compliance and call out those that have patterns of violations. But in doing so, are they then putting lesser weight on those that might have better compliance but lower crash rates? And if so, what should be a higher priority, both for the purpose of enforcement but also third parties reviews? And then the question is, do these industry averages support individual determinations? So when we say that on average as scores rise, so do crash risks. Can we say that that's true for every carrier with high scores, or do some carriers have high scores because of regional enforcement disparities or other anomalies? And how strong are these relationships? Are we saying that a fleet that has high scores is much, much more crash prone? And the data suggests that these fleets have a crash risk that is 30 to 40% higher, not double, not triple, but 30% higher. So it's not 200% or 300%. And then ultimately, the question is this: is this a program good enough? Are these scores good enough for both overarching purposes? There's a public policy question when looking at these scores to say, are they good enough that we should focus our enforcement resources? And that's a question of effective use of federal money and effectiveness of the agency. But the second question is then, are they reliable enough to give them to third parties and encourage them to make safety-based business decisions? And so on that note, I think we want to dig a little deeper into what are some of these disparities in data that can impact carrier scores and affect them when they're being evaluated by third parties based on the safety information to that end, I'm going to invite Steve and Brian, the CEO and founder of Vigilo, to talk a bit more about that. So, Steve, I believe the floor is yours.
Well, thank you very much, Rob. And I will now see if I can juggle our technology over here and switch it to my slides. So I think I'm seeing it here, so somebody inform me if I'm wrong. Great introduction, Rob, and always a pleasure to participate in these with the great mind at the American Trucking Association. So what Vigilo does is digs into the data. We do this for several thousand trucking companies, and we study a lot of this data. So what I'm going to do very quickly here today is go over three topics, and we're going to dive a little bit deeper into some specific examples of this regional or state enforcement disparity that Rob just described. We're going to talk a little bit about where the crash indicator is in terms of the 7 basics. Is it, as Rob just gave us a little teaser, is it really aligned with the basics? Are they predictive of future crashes? And then we're going to give an example of some of the odd results that you can get by virtue of being in certain safety event groups. So real quickly, I'll just go through these. Let's see if I can get the slide to advance. All right, so let's start with regional enforcement disparity. So I have created an example here that actually was inspired by one of Rob's partners over at the ATA, Dave Osheki. Dave wrote an article earlier this year in Transport Topics, and the theme of the article was proposing that law enforcement across the country was spending an inordinate amount of their effort looking at things like maintenance violations, things that they're finding at the scales and at the inspection stations, versus those traffic enforcement type of enforcement, speeding, unsafe driving, those reckless driving, those type of things. And Dave's thesis in this article was that it was all out of balance and that we ought to be spending more time doing traffic enforcement and balancing that out a bit with these somewhat minor violations that we see at roadside. So I ran some numbers, and I created this screen that you see in front of you here as a kind of a proxy for that theory, for Dave's theory. And what we see here is that for the 2012 years, this comes from the MICMAS data, so this is all data. This is not just our customers. This is every one of the violations written in the United States for the year 2012 that fall into the CSA SMS category. So you can see there's 1.1 million lighting violations versus 97,000 speeding violations for a ratio of about 12 to 1, what I have now dubbed the light speed ratio. So that, first of all, enforces Dave's theory that there is an inordinate imbalance between focus on relatively minor maintenance violations versus what some would say are the more important safety-related speeding violations. So let's take that now, this minute light speed ratio, and let's scatter it around the country and see state by state whether we are getting consistency around the country, notwithstanding whether we think the balance is right or wrong, but is everyone doing it about the same? And I think what you see, we'll just kind of shotgun around here. We've got South Carolina, Florida, Louisiana, and Indiana. And you can see they run the gamut from South Carolina, which runs at about that same national average of 12 to 1. Florida's well more than double that at 28 to 1. Louisiana is up over 40 to 1. And again, what this means, for every 1 speeding-related violations, they write 40 lamp or lighting-related violations. And then the famous and notorious Indiana, everyone who has paid attention to this literally since CSA has launched has understood that Indiana wears a badge that says we crack down on speeding. And this data shows just how much more balanced they are, barely 2 to 1, speeding versus lighting violations. I personally would congratulate Indiana. Well, I think sometimes people who operate there think they're unfairly targeted for speeding. If you look at what CSA's goals are, which is to reduce injuries and fatalities, I think a better balance and more emphasis on these speeding violations is probably a good thing. And then our final slide I'm going to pull up here. I like to show this one. This is our friends in Texas who really, really, really don't like it if your lights and lamps are not working. So you can see in this case, In Texas, they write 321 lighting violations for every one speeding-related violation. So I think this begins to show just how disparate. This is just one example. If I had a lot more time, I could go through a lot of different examples beyond just this one light speed ratio where we see really wildly disparate treatment throughout the country, state by state. Since we're picking on Texas, I'm going to show you an example. Now, this is a very cluttered-looking slide, so don't try to read into the details. This is what's known as a heat map. So just look at the colors. Blue is maintenance, brown is hours of service, orange is unsafe, green is fitness, etc. These represent all 5.2 million violations that were written in the United States against motor carriers in the year 2012. And they're broken down. The size of each of the little boxes is an individual violation. The larger the box, the more violations. So I'm going to now surround just the state of Texas, just in maintenance, to give you a kind of a visual as to just how focused, first of all, the state of Texas is in general. Look at that red box versus just about anything else you see on the screen, the size of it. And remember that all we're doing is looking at maintenance violations in Texas. So very lopsided if you look at CSA towards Texas and towards maintenance. Another example here, since I'm picking on Texas, I'm sure there's some Texans on the phone, and I do not mean to pick on you, but it's just too great a temptation to resist. I'm going to pick one specific violation, windshield wipers. This is a windshield wiper violation just in the state of Texas, and I've drawn a box around that. And then for comparison purposes, if you look in the lower right, I've just popped up another box. You can see that there are about 16 times more windshield wiper violations in the state of Texas than there are all drug and alcohol violations in the United States. So you start to see where the emphasis of CSA really is, and we can, again, bounce around the country and look at all kinds of different state examples. But I think this shows that truly this disparate treatment exists, and it's something that carriers need to understand and deal with as you operate in and around your different lanes and across your different states. This last summer, Vigilo did a little bit of work on counties. We kind of dove a little deeper into the data and discovered that we could map CSA not only to the states but to counties, and found something really interesting. I'm going to just share one of those findings with you here. This is a map of all roughly 3,200 U.S. counties in the lower 48. And what caught my eye was the dark blue down there along the southwest border. Dark blue meaning more CSA points come from those counties than the lighter blue counties. So I ran a little query, and I dug a little deeper, and I said, show me the top 10 counties for just generating CSA points. I just want to see who in the year 2012 generated the most CSA points by county, and these top 10 counties popped up. And as I've been known to say, I thought I'd made a mistake because I thought what I pulled up was the Republican Party immigration reform plan. But upon closer inspection, you can see that in those 10 what are largely border counties, 4 of them in Texas, 7 of them along the Mexican border, and a couple scattered then through California. Those 10 counties alone, of 3,200 counties, those 10 generate about 5 million CSA points versus the entire nation, which was about 20 million. So about 25% of all CSA activity comes from these 10 counties alone. So if you are a cross-border operator or operate down in the Southwest, something to be aware of. The next topic we're going to cover real quickly is the crash indicator. I have one slide on this that I think you might find interesting. What we did here was we simply looked at all 7 basics and the average percentile score for carriers who have scores for the years 2011 and 2012. The question we posed was, in general, is the industry getting better in terms of percentiles, or are they getting worse, or are they staying the same? So you can see the only one of the 7 basics that has actually improved, decreased from 11 to 12 is the bottom, is maintenance, down 1%. All the rest of them are up, some very slightly, 0.07% in fitness. The others are up 1 or 2%. But you can see substance and crash are up 6%, which in a system this big with this much data and this much activity, a 6% change is pretty darn significant. So we ask ourselves, well, is the system actually tracking to get everybody better, or is it fact everybody seems to be drifting to higher scores? Well, the thing that's interesting is the comparison then of crash count, and I've added that now to the top of the screen. So for this industry, where you see the basic percentiles creeping up slightly overall, there's actually a pretty significant 4% drop in the number of crashes. So this, to me, is a real indicator that there's some issues in here. For people who look at percentile scores, customers, brokers, insurance, etc., it is advisable, and I would encourage you all to make sure that your business partners understand that there are issues in this data that they need to dive into a little bit deeper before they judge you just on your basic scores. Now, finally, I'm going to jump into one oddity that we've seen, and many of you have probably seen this, and this is what I call fun with safety event groups. So this is an example. It's a real carrier who was facing a challenge. They had high unsafe driving percentile scores. And the safety director at this fleet decided he was going to attack this problem, and his strategy was to work with the drivers to help them understand that they needed to not be pulled over. And if you don't get pulled over, you don't get inspected. So over a 2-year period, you can see the number of inspections declined fairly dramatically. That goal was accomplished. The violations contained within those inspections also dropped significantly over that same 2-year period. And the basic measure, this is the mathematical calculation that is CSA that produces a number that then gets thrown into the hopper and creates your percentile ranking. But this is really the number you can control. This is your basic measure. And in this case, this safety director's activity was successful in decreasing their basic measure trend. So he's probably wondering how big his raise is going to be this year. Fact of the matter is he was fired. He was fired because his basic percentile did not change over that same 2-year period. So you can see it went down a little, came right back up again. So for these measures, violations down, inspections down, basic measure down, percentile stays flat, goes up a tick. So this is a result of what happens when you get a relative scoring system. I'll leave you with a little story. I'm sure you've all heard it. There's 2 hunters out in the woods, bears coming at them from across the field, and one of them starts to panic and says, we got to get out of here. The other one sits slowly and puts on his sneakers, and his partner says, what are you doing? You can't outrun the bear. And he says, I don't have to. I just have to outrun you. And that's what's going on here is all of these carriers that are getting better have to be getting better at a faster rate than the other carriers that are in their safety event group. So that's a real quick overview of a couple of the oddities that we see in the data. I'm going to hand it over now to Ted Perryman, who is going to take us through some of the legalities of this, and I think you'll enjoy what he has to say.
And Ted, we can now see your screen. If you want to make sure you unmute your line, you can go ahead and get started.
Thank you very much, everyone. Now that Rob and Steve have pointed out some of the problems with the reliability of CSA percentile rankings, we are confronted with the issue of how CSA scores will be used in accident cases involving motor carriers. One of the fundamental principles of our judicial system is that evidence that is presented to a jury must be relevant, reliable, and trustworthy. As Rob and Steve have pointed out, CSA just might not meet the required legal standard. Since the advent of CSA in December of 2010, those of us who defend trucking companies have struggled with the use of CSA scores being used against a motor carrier in a courtroom. While as attorneys we struggle with their relevance and trustworthiness, one thing is very clear, is our adversaries, personal injury lawyers who are on the other side, have no hesitancy in trying to paint the motor carrier as being unsafe through CSA data. I'm going to show you a few slides here, I think, that illustrate the point. This is taken from a chapter in a book called Litigating Truck Accident Cases that was written by a plaintiff's attorney. And it's clear as you look at this that that the plaintiff's bar intends to use CSA offensively against the industry. Now, while we may dispute how much the agency has listened to our input or that of the ATA, there's no dispute that Mr. Leserman is telling his colleagues to use CSA. And you'll note in the second paragraph there's a comment about there being no sound evidentiary reason not to admit CSA evidence. It's clear that Mr. Leserman has not considered the research that's been developed, nor has he listened to Rob and Steve discuss the issue. Here's yet another example. This was taken from Trial Lawyers magazine, and clearly the author misunderstands CSA because, especially as to its intent. But you can see, and this is just another example of what we can expect when we start defending accident cases since the advent of CSA. And most of you who have been through this process, again, where a lawsuit's been filed against a motor carrier, it usually begins with what we call the discovery process. And one of the first things that are filed are interrogatories. And here are some examples of interrogatories. And this is in that same Trial Lawyers magazine. These are the questions that you're likely to get if you're a motor carrier. You know, it's kind of interesting. Rob and Steve just spent 20 minutes explaining why the basic scores may be incorrect or unjustified. I suspect, if given the time, they could probably talk 2 hours on the subject. Here, you're asked to explain why you think that the measurement is incorrect or unjustified. So I think as we develop more information in this area, it'll be helpful answering questions such as this. Here's yet another example of what we call request to admit. This is, I think, typical of what you're going to see in a accident case from a plaintiff's lawyer. And these, again, I have a suspicion. I know how Rob and Steve would answer these discovery requests, but again, this is what you can expect to encounter as you face this. In general, I think when we talk about CSA evidence, there are essentially 4 types. One is the percentile ranking, which we're all familiar with, and of course the roadside inspections that make up the data, any citations or violations of the regulations or state law, and of course crashes. In my mind, all 4 of these types of evidence fall into the category of what I think lawyers generally call character evidence. You know, none of these 4 have anything whatsoever to do with a particular crash that may be involved in a lawsuit. Instead, this evidence actually goes to the issue of what I loosely refer to as the character of the company. For example, the fact that a motor carrier has an alert and an hours of service compliance does not suggest that the driver in a particular crash was fatigued at the time. So consequently, CSA is not being offered to prove that the truck driver caused the crash. Instead, it's being offered to prove that the trucking company itself is an unsafe motor carrier and should be found at fault. Fortunately, our rules of evidence do not permit that type of evidence in most cases. What I call character evidence is simply generally not admissible. However, there is an exception, and I've just taken Rule 404 from the Federal Rules of Evidence, and the exception says that character evidence may be admissible for another purpose other than proving who caused the accident. It could be used for proving motive, opportunity, intent, and the rest of what you see there. If it's used in this context, it very well could become admissible in a particular case. The problem is by making simple allegations and what I call pleading the right words in a complaint, CSA suddenly becomes admissible. By making allegations of intent, motive, knowledge, or any of those kinds of things, our brethren in the plaintiff's bar will attempt to circumvent the general rule and try to bring it within the exception of Rule 404. A good example of this would be negligence claims made directly against the motor carrier, such as negligent hiring, negligent retention, failure to train, those types of claims where you're trying to prove some type of intent or knowledge. I suspect CSA, you're going to see CSA scores. The ultimate issue here, at least in my mind, is does CSA in the percentile rankings does it really reflect how safe the motor carrier is operating? In other words, does it reflect or depict the character of the company? Well, I think, and I throw this slide up here, and this is the disclaimer that you'll find when you go to the FMCSA website. And here I think is the best tool that we may have to prevent CSA evidence from coming into the courtroom, and that's just the general disclaimer. Here, this disclaimer clearly says, in plain English, that it's not safety fitness determination, nor is it a rating, and it's not final. In my mind, this should be the beginning and the end, but I suspect it won't be, especially in certain areas of the country where this is going to be litigated. But I think this is probably the best thing we have at this point of showing that it's not reliable or trustworthy. In a courtroom context, this burden is going to be on the motor carrier to establish untrustworthiness, and unfortunately, it's probably going to have to be on a case-by-case basis, depending on the facts of the case and on the motor carrier. I think, as Rob and Steve have both outlined, here are some examples of unreliability. The research studies have been mentioned. There are statistical outliers, and as Steve mentioned, the regional enforcement disparity. All these things, I think, can be used to show that it's unreliable, therefore it cannot reflect on the character of the company. And I think probably we can agree that in most, when we're talking about CSA, it was not designed nor was it implemented to reflect character. Here are some of the problems with CSA in the courtroom. As I said, high scores or rankings will be used to reflect on the character, and as has been pointed out, they are sometimes misleading. Those alert symbols, you can see those blown up in a courtroom context, showing that the motor carrier is unsafe. And I would submit that even if you're more than 50% in a given category, that reflects negatively on the carrier. So these are just some of the problems with the use of CSA in the context of alerts and the other data that we've talked about. And finally, I'd like to add that it's important that we continue our research into this and challenge the use of CSA in the courtroom. In my mind, accidents involving motor carriers should not be decided on the basis of the character of the company when the character is being defined by CSA data. That I think we can probably, most of us will agree on this call, that the data is neither relevant nor reliable. Thank you very much, and if you have any questions, please feel free.
And thank you very much, Ted and Steve and Rob. And we at Cline University are very sensitive to your time today, and because of that, what we're going to do is, instead of having a Q&A session, we're going to launch a poll. If you would like a copy of the slides, if you'd like information from Cline Wood, if you'd like information from the speakers, please feel free to respond to that poll or send any specific questions that you have in via the chat box or question box, and we'll try to get back to everybody via phone or email shortly. And while this poll's up, we'll have that poll up for 60 to 90 seconds. I want to take this opportunity to once again thank everybody. We had a very large audience who attended today. We had 3 tremendous speakers, and of course want to once again thank our sponsors, Cline University, for bringing these educational transportation monthly web seminars to the trucking industry. With that, today's web seminar is now ending. After this poll closes, we will close the webinar. We hope you all have a great day.